Convention on the Prohibition of the Development, Production, Stockpiling and Use of Chemical Weapons and on Their Destruction. Done at Geneva on 3 September 1992, entry into force, 29 April 1997. The states parties to this convention. Preamble. Determined to act with a view to achieving effective progress towards general and complete disarmament under strict and effective international control, including the prohibition and elimination of all types of weapons of mass destruction. Desiring to contribute to the realization of the purposes and principles of the Charter of the United Nations. Recalling that the General Assembly of the United Nations has repeatedly condemned all actions contrary to the principles and objectives of the Protocol for the Prohibition of the Use in War of asphyxiating, poisonous or other gases, and of bacteriological methods of warfare, signed at Geneva on 17 June 1925, the Geneva Protocol of 1925. Recognizing that this convention reaffirms principles and objectives of and obligations assumed under the Geneva Protocol of 1925, and the Convention on the Prohibition of the Development, Production and Stockpiling of Bacteriological, Biological, and Toxin Weapons and on Their Destruction signed at London, Moscow and Washington on 10 April 1972. Bearing in mind the objective contained in Article 9 of the Convention on the Prohibition of the Development, Production and Stockpiling of Bacteriological, Biological, and Toxin Weapons and on Their Destruction. Determined for the sake of all mankind, to exclude completely the possibility of the use of chemical weapons, through the implementation of the provisions of this Convention, thereby complementing the obligations assumed under the Geneva Protocol of 1925. Recognizing the prohibition, embodied in the pertinent agreements and relevant principles of international law, of the use of herbicides as a method of warfare. Considering that achievements in the field of chemistry should be used exclusively for the benefit of mankind. Desiring to promote free trade in chemicals as well as international cooperation and exchange of scientific and technical information in the field of chemical activities for purposes not prohibited under this convention in order to enhance the economic and technological development of all states parties. Convinced that the complete and effective prohibition of the development, production, acquisition, stockpiling, retention, transfer and use of chemical weapons, and their destruction, represent a necessary step towards the achievement of these common objectives. Have agreed as follows. Article I. General Obligations. 1. Each state party to this convention undertakes never under any circumstances a. to develop, produce, otherwise acquire, stockpile or retain chemical weapons, or transfer, directly or indirectly, chemical weapons to anyone. B. To use chemical weapons. C. To engage in any military preparations to use chemical weapons. D. To assist, encourage or induce, in any way, anyone to engage in any activity prohibited to a state party under this convention. 2. Each state party undertakes to destroy chemical weapons it owns or possesses, or that are located in any place under its jurisdiction or control, in accordance with the provisions of this convention. 3. Each state party undertakes to destroy all chemical weapons it abandoned on the territory of another state party, in accordance with the provisions of this convention. 4. Each state party undertakes to destroy any chemical weapons production facilities it owns or possesses, or that are located in any place under its jurisdiction or control, in accordance with the provisions of this convention. 5. Each state party undertakes not to use riot control agents as a method of warfare. Article 2. Definitions and criteria. For the purposes of this convention. 1. Chemical weapons means the following, together or separately. A. Toxic chemicals and their precursors, except where intended for purposes not prohibited under this convention, as long as the types and quantities are consistent with such purposes. B. munitions and devices, specifically designed to cause death or other harm through the toxic properties of those toxic chemicals specified in subparagraph A, which would be released as a result of the employment of such munitions and devices. C. Any equipment specifically designed for use directly in connection with the employment of munitions and devices specified in subparagraph B. 2. Toxic chemical means any chemical which through its chemical action on life processes can cause death, temporary incapacitation or permanent harm to humans or animals. This includes all such chemicals, regardless of their origin or of their method of production, and regardless of whether they are produced in facilities, in munitions or elsewhere. For the purpose of implementing this convention, toxic chemicals which have been identified for the application of verification measures are listed in schedules contained in the Annex on Chemicals. 3. Precursor means any chemical reactant which takes part at any stage in the production by whatever method of a toxic chemical. This includes any key component of a binary or multi-component chemical system. For the purpose of implementing this convention, precursors which have been identified for the application of verification measures are listed in schedules contained in the Annex on Chemicals. 4. Key component of binary or multi-component chemical systems, hereinafter referred to as key component, means the precursor which plays the most important role in determining the toxic properties of the final product and reacts rapidly with other chemicals in the binary or multi-component system. 5. Old chemical weapons means A. Chemical weapons which were produced before 1925 or B. Chemical weapons produced in the period between 1925 and 1946 that have deteriorated to such extent that they can no longer be used as chemical weapons. 6. Abandoned chemical weapons means chemical weapons, including old chemical weapons, abandoned by a state after the 1st of January 1925 on the territory of another state without the consent of the latter. 7. Riot control agent means any chemical not listed in a schedule, which can produce rapidly in humans sensory irritation or disabling physical effects which disappear within a short time following termination of exposure. 8. Chemical weapons production facility. A. Means any equipment, as well as any building housing such equipment, that was designed, constructed or used at any time since the 1st of January 1946. I. As part of the stage in the production of chemicals, final technological stage, where the material flows would contain, when the equipment is in operation. 1. Any chemical listed in Schedule 1 in the Annex on Chemicals or 2. Any other chemical that has no use, above 1 ton per year on the territory of a state party or in any other place under the jurisdiction or control of a state party, for purposes not prohibited under this convention, but can be used for chemical weapons purposes. Or 2. For filling chemical weapons, including, inter alia, the filling of chemicals listed in Schedule 1 into munitions. Devices or bulk storage containers. The filling of chemicals into containers that form part of assembled binary munitions and devices or into chemical submunitions that form part of assembled unitary munitions and devices, and the loading of the containers and chemical submunitions into the respective munitions and devices. B. Does not mean I. Any facility having a production capacity for synthesis of chemicals specified in subparagraph A. I. that is less than 1 ton. 2. Any facility in which a chemical specified in subparagraph A. I. is or was produced as an unavoidable byproduct of activities for purposes not prohibited under this convention. Provided that the chemical does not exceed 3% of the total product and that the facility is subject to declaration and inspection under the Annex on Implementation and Verification, hereinafter referred to as Verification Annex, or 3. the single small-scale facility for production of chemicals listed in Schedule 1 for purposes not prohibited under this convention as referred to in Part 6 of the Verification Annex. 9. Purposes not prohibited under this convention means a. Industrial, agricultural, research, medical, pharmaceutical or other peaceful purposes. b. Protective purposes, namely those purposes directly related to protection against toxic chemicals and to protection against chemical weapons. c. Military purposes not connected with the use of chemical weapons and not dependent on the use of the toxic properties of chemicals as a method of warfare. d. Law enforcement including domestic riot control purposes. 10. Production capacity means the annual quantitative potential for manufacturing a specific chemical based on the technological process actually used or, if the process is not yet operational, planned to be used at the relevant facility. It shall be deemed to be equal to the nameplate capacity or, if the nameplate capacity is not available, to the design capacity. The nameplate capacity is the product output under conditions optimized for maximum quantity for the production facility, as demonstrated by one or more test runs. The design capacity is the corresponding theoretically calculated product output. 11. Organization means the organization for the prohibition of chemical weapons established pursuant to Article 8 of this convention. 12. For the purposes of Article V. A. Production of a chemical means its formation through chemical reaction. B. Processing of a chemical means a physical process, such as formulation, extraction and purification, in which a chemical is not converted into another chemical. C. Consumption of a chemical means its conversion into another chemical via a chemical reaction. Article 3. Declarations. 1. Each state party shall submit to the organization, not later than 30 days after this convention enters into force for it, the following declarations, in which it shall: a. With respect to chemical weapons. I. Declare whether it owns or possesses any chemical weapons, or whether there are any chemical weapons located in any place under its jurisdiction or control. 2. Specify the precise location, aggregate quantity and detailed inventory of chemical weapons it owns or possesses, or that are located in any place under its jurisdiction or control, in accordance with Part 4a, paragraphs 1 to 3, of the Verification Annex, except for those chemical weapons referred to in subparagraph 3. 3. Report any chemical weapons on its territory that are owned and possessed by another state and located in any place under the jurisdiction or control of another state, in accordance with Part 4a, paragraph 4 of the Verification Annex. 4. Declare whether it has transferred or received, directly or indirectly, any chemical weapons since the 1st of January 1946 and specify the transfer or receipt of such weapons, in accordance with Part 4a, paragraph 5, of the Verification Annex. v. Provide its general plan for destruction of chemical weapons that it owns or possesses, or that are located in any place under its jurisdiction or control, in accordance with Part 4a, paragraph 6, of the Verification Annex. b. With respect to old chemical weapons and abandoned chemical weapons. I. Declare whether it has on its territory old chemical weapons and provide all available information in accordance with Part 4b, paragraph 3, of the Verification Annex. 2. Declare whether there are abandoned chemical weapons on its territory and provide all available information in accordance with Part 4b, paragraph 8 of the Verification Annex. 3. Declare whether it has abandoned chemical weapons on the territory of other states and provide all available information in accordance with Part 4b, paragraph 10 of the Verification Annex. C. With respect to chemical weapons production facilities. I. declare whether it has or has had any chemical weapons production facility under its ownership or possession, or that is or has been located in any place under its jurisdiction or control at any time since the 1st of January 1946. 2. Specify any chemical weapons production facility it has or has had under its ownership or possession, or that is or has been located in any place under its jurisdiction or control at any time since the 1st of January 1946, in accordance with Part 5, Paragraph 1, of the Verification Annex. Except for those facilities referred to in subparagraph 3. 3. Report any chemical weapons production facility on its territory that another state has or has had under its ownership and possession, and that is or has been located in any place under the jurisdiction or control of another state at any time since the 1st of January 1946, in accordance with Part 5, Paragraph 2, of the Verification Annex. 4. Declare whether it has transferred or received, directly or indirectly, any equipment for the production of chemical weapons since the 1st of January 1946, and specify the transfer or receipt of such equipment, in accordance with Part 5, Paragraphs 3 to 5, of the Verification Annex. V. Provide its general plan for destruction of any chemical weapons production facility it owns or possesses, or that is located in any place under its jurisdiction or control, in accordance with Part 5, Paragraph 6 of the Verification Annex. Vi. Specify actions to be taken for closure of any chemical weapons production facility it owns or possesses, or that is located in any place under its jurisdiction or control, in accordance with Part 5, Paragraph 1, I, of the Verification Annex. 7. Provide its general plan for any temporary conversion of any chemical weapons production facility it owns or possesses, or that is located in any place under its jurisdiction or control, into a chemical weapons destruction facility, in accordance with Part 5, Paragraph 7, of the Verification Annex. D. With respect to other facilities, specify the precise location, nature and general scope of activities of any facility or establishment under its ownership or possession, or located in any place under its jurisdiction or control, and that has been designed, constructed or used since the 1st of January 1946 primarily for development of chemical weapons. Such declaration shall include, inter alia, laboratories and test and evaluation sites, e. With respect to riot control agents, specify the chemical name, structural formula and chemical abstracts service, CAS, registry number, if assigned, of each chemical it holds for riot control purposes. This declaration shall be updated not later than 30 days after any change becomes effective. 2. The provisions of this article and the relevant provisions of Part 4 of the Verification Annex shall not, at the discretion of a state party, apply to chemical weapons buried on its territory before the 1st of January 1977 and which remain buried, or which had been dumped at sea before the 1st of January 1985. Article 4. Chemical weapons. 1. The provisions of this article and the detailed procedures for its implementation shall apply to all chemical weapons owned or possessed by a state party, or that are located in any place under its jurisdiction or control, except old chemical weapons and abandoned chemical weapons to which Part 4, b, of the Verification Annex applies. 2. Detailed procedures for the implementation of this article are set forth in the Verification Annex. 3. All locations at which chemical weapons specified in Paragraph 1 are stored or destroyed shall be subject to systematic verification through on-site inspection and the monitoring with on-site instruments, in accordance with Part 4a of the Verification Annex. 4. Each state party shall, immediately after the declaration under Article 3, Paragraph 1a, has been submitted, provide access to chemical weapons specified in paragraph 1 for the purpose of systematic verification of the declaration through on-site inspection. Thereafter, each state party shall not remove any of these chemical weapons, except to a chemical weapons destruction facility. It shall provide access to such chemical weapons, for the purpose of systematic on-site verification. 5. Each state party shall provide access to any chemical weapons destruction facilities and their storage areas, that it owns or possesses, or that are located in any place under its jurisdiction or control, for the purpose of systematic verification through on-site inspection and the monitoring with on-site instruments. 6. Each state party shall destroy all chemical weapons specified in paragraph 1 pursuant to the verification annex and in accordance with the agreed rate and sequence of destruction, hereinafter referred to as order of destruction. Such destruction shall begin not later than 2 years after this convention enters into force for it and shall finish not later than 10 years after entry into force of this convention. A state party is not precluded from destroying such chemical weapons at a faster rate. 7. Each state party shall a. Submit detailed plans for the destruction of chemical weapons specified in paragraph 1 not later than 60 days before each annual destruction period begins, in accordance with Part 4a, paragraph 29, of the verification annex. The detailed plans shall encompass all stocks to be destroyed during the next annual destruction period. b. Submit declarations annually regarding the implementation of its plans for destruction of chemical weapons specified in paragraph 1, not later than 60 days after the end of each annual destruction period, and c. Certify, not later than 30 days after the destruction process has been completed, that all chemical weapons specified in paragraph 1 have been destroyed. 8. If a state ratifies or accedes to this convention after the 10-year period for destruction set forth in paragraph 6, it shall destroy chemical weapons specified in paragraph 1 as soon as possible. The order of destruction and procedures for stringent verification for such a state party shall be determined by the Executive Council. 9. Any chemical weapons discovered by a state party after the initial declaration of chemical weapons shall be reported, secured and destroyed in accordance with Part 4a of the Verification Annex. 10. Each state party, during transportation, sampling, storage and destruction of chemical weapons, shall assign the highest priority to ensuring the safety of people and to protecting the environment. Each state party shall transport, sample, store and destroy chemical weapons in accordance with its national standards for safety and emissions. 11. Any state party which has on its territory chemical weapons that are owned or possessed by another state, or that are located in any place under the jurisdiction or control of another state, shall make the fullest efforts to ensure that these chemical weapons are removed from its territory not later than 1 year after this convention enters into force for it. If they are not removed within 1 year, the state party may request the organization and other states parties to provide assistance in the destruction of these chemical weapons. 12. Each state party undertakes to cooperate with other states parties that request information or assistance on a bilateral basis or through the Technical Secretariat regarding methods and technologies for the safe and efficient destruction of chemical weapons. 13. In carrying out verification activities pursuant to this article and Part 4a of the Verification Annex, the organization shall consider measures to avoid unnecessary duplication of bilateral or multilateral agreements on verification of chemical weapons storage and their destruction among states parties. To this end, the Executive Council shall decide to limit verification to measures complementary to those undertaken pursuant to such a bilateral or multilateral agreement, if it considers that a. Verification provisions of such an agreement are consistent with the verification provisions of this article and Part 4a of the Verification Annex. b. Implementation of such an agreement provides for sufficient assurance of compliance with the relevant provisions of this convention. And c. Parties to the bilateral or multilateral agreement keep the organization fully informed about their verification activities. 14. If the Executive Council takes a decision pursuant to paragraph 13, the organization shall have the right to monitor the implementation of the bilateral or multilateral agreement. 15. Nothing in paragraphs 13 and 14 shall affect the obligation of a state party to provide declarations pursuant to Article 3, this article and Part 4a of the Verification Annex. 16. Each state party shall meet the costs of destruction of chemical weapons it is obliged to destroy. It shall also meet the costs of verification of storage and destruction of these chemical weapons unless the Executive Council decides otherwise. If the Executive Council decides to limit verification measures of the organization pursuant to paragraph 13, the costs of complementary verification and the monitoring by the organization shall be paid in accordance with the United Nations Scale of Assessment, as specified in Article 8, Paragraph 7. 17. The provisions of this article and the relevant provisions of Part 4 of the Verification Annex shall not, at the discretion of a state party, apply to chemical weapons buried on its territory before the 1st of January 1977 and which remain buried, or which had been dumped at sea before the 1st of January 1985. Article V. Chemical Weapons Production Facilities. 1. The provisions of this article and the detailed procedures for its implementation shall apply to any and all chemical weapons production facilities owned or possessed by a state party, or that are located in any place under its jurisdiction or control. 2. Detailed procedures for the implementation of this article are set forth in the Verification Annex. 3. All chemical weapons production facilities specified in paragraph 1 shall be subject to systematic verification through on-site inspection and the monitoring with on-site instruments in accordance with Part 5 of the Verification Annex. 4. Each state party shall cease immediately all activity at chemical weapons production facilities specified in paragraph 1, except activity required for closure. 5. No state party shall construct any new chemical weapons production facilities or modify any existing facilities for the purpose of chemical weapons production or for any other activity prohibited under this convention. 6. Each state party shall, immediately after the declaration under Article 3, Paragraph 1, c, has been submitted, provide access to chemical weapons production facilities specified in Paragraph 1, for the purpose of systematic verification of the declaration through on-site inspection. 7. Each state party shall a. Close, not later than 90 days after this convention enters into force for it, all chemical weapons production facilities specified in Paragraph 1, in accordance with Part 5 of the Verification Annex, and give notice thereof and b. Provide access to chemical weapons production facilities specified in Paragraph 1, subsequent to closure, for the purpose of systematic verification through on-site inspection and the monitoring with on-site instruments in order to ensure that the facility remains closed and is subsequently destroyed. 8. Each state party shall destroy all chemical weapons production facilities specified in Paragraph 1 and related facilities and equipment, pursuant to the Verification Annex and in accordance with an agreed rate and sequence of destruction, hereinafter referred to as Order of Destruction. Such destruction shall begin not later than 1 year after this convention enters into force for it, and shall finish not later than 10 years after entry into force of this convention. A state party is not precluded from destroying such facilities at a faster rate. 9. Each state party shall a. Submit detailed plans for destruction of chemical weapons production facilities specified in paragraph 1, not later than 180 days before the destruction of each facility begins. b. Submit declarations annually regarding the implementation of its plans for the destruction of all chemical weapons production facilities specified in paragraph 1, not later than 90 days after the end of each annual destruction period, and c. Certify, not later than 30 days after the destruction process has been completed, that all chemical weapons production facilities specified in paragraph 1 have been destroyed. 10. If a state ratifies or accedes to this convention after the 10-year period for destruction set forth in paragraph 8, it shall destroy chemical weapons production facilities specified in paragraph 1 as soon as possible. The order of destruction and procedures for stringent verification for such a state party shall be determined by the Executive Council. 11. Each state party, during the destruction of chemical weapons production facilities, shall assign the highest priority to ensuring the safety of people and to protecting the environment. Each state party shall destroy chemical weapons production facilities in accordance with its national standards for safety and emissions. 12. Chemical weapons production facilities specified in paragraph the first of may be temporarily converted for destruction of chemical weapons in accordance with Part 5, paragraphs 18 to 25, of the Verification Annex. Such a converted facility must be destroyed as soon as it is no longer in use for destruction of chemical weapons, but, in any case, not later than 10 years after entry into force of this convention. 13. A state party may request, in exceptional cases of compelling need, permission to use a chemical weapons production facility specified in paragraph 1 for purposes not prohibited under this convention. Upon the recommendation of the Executive Council, the Conference of the States Parties shall decide whether or not to approve the request and shall establish the conditions upon which approval is contingent in accordance with Part 5, Section D, of the Verification Annex. 14. The chemical weapons production facility shall be converted in such a manner that the converted facility is not more capable of being reconverted into a chemical weapons production facility than any other facility used for industrial, agricultural, research, medical, pharmaceutical or other peaceful purposes not involving chemicals listed in Schedule 1. 15. All converted facilities shall be subject to systematic verification through on-site inspection and the monitoring with on-site instruments in accordance with Part 5, Section D, of the Verification Annex. 16. In carrying out verification activities pursuant to this article and Part 5 of the Verification Annex, the organization shall consider measures to avoid unnecessary duplication of bilateral or multilateral agreements on verification of chemical weapons production facilities and their destruction among states parties. To this end, the Executive Council shall decide to limit the verification to measures complementary to those undertaken pursuant to such a bilateral or multilateral agreement, if it considers that a. Verification provisions of such an agreement are consistent with the verification provisions of this article and Part 5 of the Verification Annex. b. Implementation of the agreement provides for sufficient assurance of compliance with the relevant provisions of this convention, and c. Parties to the bilateral or multilateral agreement keep the organization fully informed about their verification activities. 17. If the Executive Council takes a decision pursuant to paragraph 16, the organization shall have the right to monitor the implementation of the bilateral or multilateral agreement. 18. Nothing in paragraphs 16 and 17 shall affect the obligation of a state party to make declarations pursuant to Article 3, this article and Part 5 of the Verification Annex. 19. Each state party shall meet the costs of destruction of chemical weapons production facilities it is obliged to destroy. It shall also meet the costs of verification under this article unless the Executive Council decides otherwise. If the Executive Council decides to limit verification measures of the organization pursuant to paragraph 16, the costs of complementary verification and the monitoring by the organization shall be paid in accordance with the United Nations Scale of Assessment, as specified in Article 8, paragraph 7. Article V. Activities not prohibited under this Convention. 1. Each state party has the right, subject to the provisions of this convention, to develop, produce, otherwise acquire, retain, transfer and use toxic chemicals and their precursors for purposes not prohibited under this convention. 2. Each state party shall adopt the necessary measures to ensure that toxic chemicals and their precursors are only developed, produced, otherwise acquired, retained, transferred, or used within its territory or in any other place under its jurisdiction or control for purposes not prohibited under this convention. To this end, and in order to verify that activities are in accordance with obligations under this convention, each state party shall subject toxic chemicals and their precursors listed in Schedules 1, 2 and 3 of the Annex on Chemicals, facilities related to such chemicals, and other facilities as specified in the Verification Annex, that are located on its territory or in any other place under its jurisdiction or control, to verification measures as provided in the Verification Annex. 3. Each state party shall subject chemicals listed in Schedule 1, hereinafter referred to as Schedule 1 chemicals, to the prohibitions on production, acquisition, retention, transfer and use as specified in Part 6 of the Verification Annex. It shall subject Schedule 1 chemicals and facilities specified in Part 6 of the Verification Annex to systematic verification through on-site inspection and the monitoring with on-site instruments in accordance with that part of the Verification Annex. 4. Each state party shall subject chemicals listed in Schedule 2, hereinafter referred to as Schedule 2 chemicals, and facilities specified in Part 7 of the Verification Annex to data monitoring and on-site verification in accordance with that part of the Verification Annex. 5. Each state party shall subject chemicals listed in Schedule 3, hereinafter referred to as Schedule 3 chemicals, and facilities specified in Part 8 of the Verification Annex to data monitoring and on-site verification in accordance with that part of the Verification Annex. 6. Each state party shall subject facilities specified in Part 9 of the Verification Annex to data monitoring and eventual on-site verification in accordance with that part of the Verification Annex unless decided otherwise by the Conference of the States Parties pursuant to Part 9, paragraph 22, of the Verification Annex. 7. Not later than 30 days after this convention enters into force for it, each state party shall make an initial declaration on relevant chemicals and facilities in accordance with the Verification Annex. 8. Each state party shall make annual declarations regarding the relevant chemicals and facilities in accordance with the Verification Annex. 9. For the purpose of on-site verification, each state party shall grant to the inspectors access to facilities as required in the Verification Annex. 10. In conducting verification activities, the Technical Secretariat shall avoid undue intrusion into the state parties' chemical activities for purposes not prohibited under this convention, and, in particular, abide by the provisions set forth in the Annex on the Protection of Confidential Information, hereinafter referred to as Confidentiality Annex. 11. The provisions of this article shall be implemented in a manner which avoids hampering the economic or technological development of states parties, and international cooperation in the field of chemical activities for purposes not prohibited under this convention, including the international exchange of scientific and technical information and chemicals and equipment for the production, processing or use of chemicals for purposes not prohibited under this convention. General undertakings. Article 7. National implementation measures. 1. Each state party shall, in accordance with its constitutional processes, adopt the necessary measures to implement its obligations under this convention. In particular, it shall a. Prohibit natural and legal persons anywhere on its territory or in any other place under its jurisdiction as recognized by international law from undertaking any activity prohibited to a state party under this convention, including enacting penal legislation with respect to such activity. b. Not permit in any place under its control any activity prohibited to a state party under this convention, and c. Extend its penal legislation enacted under subparagraph a to any activity prohibited to a state party under this convention undertaken anywhere by natural persons, possessing its nationality, in conformity with international law. 2. Each state party shall cooperate with other states parties and afford the appropriate form of legal assistance to facilitate the implementation of the obligations under paragraph 1. 3. Each state party, during the implementation of its obligations under this convention, shall assign the highest priority to ensuring the safety of people and to protecting the environment, and shall cooperate as appropriate with other states parties in this regard. Relations between the state party and the organization. 4. In order to fulfill its obligations under this convention, each state party shall designate or establish a national authority to serve as the national focal point for effective liaison with the organization and other states parties. Each state party shall notify the organization of its national authority at the time that this convention enters into force for it. 5. Each state party shall inform the organization of the legislative and administrative measures taken to implement this convention. 6. Each state party shall treat as confidential and afford special handling to information and data that it receives in confidence from the organization in connection with the implementation of this convention. It shall treat such information and data exclusively in connection with its rights and obligations under this convention and in accordance with the provisions set forth in the Confidentiality Annex. 7. Each state party undertakes to cooperate with the organization in the exercise of all its functions and in particular to provide assistance to the Technical Secretariat. Article 8. The Organization. A. General Provisions. 1. The states parties to this convention hereby establish the Organization for the Prohibition of Chemical Weapons to achieve the object and purpose of this convention, to ensure the implementation of its provisions, including those for international verification of compliance with it, and to provide a forum for consultation and cooperation among states parties. 2. All states parties to this convention shall be members of the organization. A state party shall not be deprived of its membership in the organization. 3. The seat of the headquarters of the organization shall be The Hague, Kingdom of the Netherlands. 4. There are hereby established as the organs of the organization, the Conference of the States Parties, the Executive Council, and the Technical Secretariat. 5. The organization shall conduct its verification activities provided for under this convention in the least intrusive manner possible, consistent with the timely and efficient accomplishment of their objectives. It shall request only the information and data necessary to fulfill its responsibilities under this convention. It shall take every precaution to protect the confidentiality of information on civil and military activities and facilities coming to its knowledge in the implementation of this convention, and, in particular, shall abide by the provisions set forth in the Confidentiality Annex. 6. In undertaking its verification activities, the organization shall consider measures to make use of advances in science and technology. 7. The costs of the organization's activities shall be paid by states parties in accordance with the United Nations scale of assessment, adjusted to take into account differences in membership between the United Nations and this organization, and subject to the provisions of Articles 4 and v. Financial contributions of states parties to the Preparatory Commission shall be deducted in an appropriate way from their contributions to the regular budget. The budget of the organization shall comprise 2 separate chapters, one relating to administrative and other costs, and one relating to verification costs. 8. A member of the organization which is in arrears in the payment of its financial contribution to the organization shall have no vote in the organization if the amount of its arrears equals or exceeds the amount of the contribution due from it for the preceding 2 full years. The conference of the states parties may, nevertheless, permit such a member to vote if it is satisfied that the failure to pay is due to conditions beyond the control of the member. b. The conference of the states parties composition, procedures and decision-making. 9. The conference of the states parties, hereinafter referred to as the conference, shall be composed of all members of this organization. Each member shall have one representative in the conference, who may be accompanied by alternates and advisers. 10. The first session of the conference shall be convened by the depository not later than 30 days after the entry into force of this convention. 11. The conference shall meet in regular sessions which shall be held annually unless it decides otherwise. 12. Special sessions of the conference shall be convened, a. when decided by the conference, b. when requested by the Executive Council, c. when requested by any member and supported by 1/3 of the members, or d. in accordance with paragraph 22 to undertake reviews of the operation of this convention. Except in the case of subparagraph d, the special session shall be convened not later than 30 days after receipt of the request by the Director General of the Technical Secretariat, unless specified otherwise in the request. 13. The conference shall also be convened in the form of an amendment conference in accordance with Article 15, paragraph 2. 14. Sessions of the conference shall take place at the seat of the organization unless the conference decides otherwise. 15. The conference shall adopt its rules of procedure. At the beginning of each regular session, it shall elect its chairman and such other officers as may be required. They shall hold office until a new chairman and other officers are elected at the next regular session. 16. A majority of the members of the organization shall constitute a quorum for the conference. 17. Each member of the organization shall have one vote in the conference. 18. The conference shall take decisions on questions of procedure by a simple majority of the members present and voting. Decisions on matters of substance should be taken as far as possible by consensus. If consensus is not attainable when an issue comes up for decision, the chairman shall defer any vote for 24 hours and during this period of deferment shall make every effort to facilitate achievement of consensus, and shall report to the conference before the end of this period. If consensus is not possible at the end of 24 hours, the conference shall take the decision by a 2/3 majority of members present and voting unless specified otherwise in this convention. When the issue arises as to whether the question is one of substance or not, that question shall be treated as a matter of substance unless otherwise decided by the conference by the majority required for decisions on matters of substance. Powers and functions. 19. The conference shall be the principal organ of the organization. It shall consider any questions, matters or issues within the scope of this convention, including those relating to the powers and functions of the Executive Council and the Technical Secretariat. It may make recommendations and take decisions on any questions, matters or issues related to this convention raised by a state party or brought to its attention by the Executive Council. 20. The conference shall oversee the implementation of this convention, and act in order to promote its object and purpose. The conference shall review compliance with this convention. It shall also oversee the activities of the Executive Council and the Technical Secretariat and may issue guidelines in accordance with this convention to either of them in the exercise of their functions. 21. The conference shall a. Consider and adopt at its regular sessions the report, program and budget of the organization, submitted by the Executive Council, as well as consider other reports. b. Decide on the scale of financial contributions to be paid by states parties in accordance with paragraph 7. c. Elect the members of the Executive Council. d. Appoint the Director General of the Technical Secretariat, hereinafter referred to as the Director General. e. Approve the rules of procedure of the Executive Council submitted by the latter. f. Establish such subsidiary organs as it finds necessary for the exercise of its functions in accordance with this convention. g. Foster international cooperation for peaceful purposes in the field of chemical activities. h. Review scientific and technological developments that could affect the operation of this convention, and, in this context, direct the Director General to establish a scientific advisory board to enable him, in the performance of his functions, to render specialized advice in areas of science and technology relevant to this convention, to the conference, the Executive Council or states parties. The Scientific Advisory Board shall be composed of independent experts appointed in accordance with terms of reference adopted by the conference. I. Consider and approve at its first session any draft agreements, provisions and guidelines developed by the Preparatory Commission. j. Establish at its first session the Voluntary Fund for Assistance in accordance with Article X. k. Take the necessary measures to ensure compliance with this convention and to redress and remedy any situation which contravenes the provisions of this convention, in accordance with Article 12. 22. The conference shall not later than 1 year after the expiry of the 5th and the 10th year after the entry into force of this convention, and at such other times within that time period as may be decided upon, convene in special sessions to undertake reviews of the operation of this convention. Such reviews shall take into account any relevant scientific and technological developments. At intervals of 5 years thereafter, unless otherwise decided upon, further sessions of the conference shall be convened with the same objective. c. The Executive Council. Composition, Procedure and Decision-Making. 23. The Executive Council shall consist of 41 members. Each state party shall have the right, in accordance with the principle of rotation, to serve on the Executive Council. The members of the Executive Council shall be elected by the conference for a term of 2 years. In order to ensure the effective functioning of this convention, due regard being specially paid to equitable geographical distribution, to the importance of chemical industry, as well as to political and security interests, the Executive Council shall be composed as follows. a. 9 states parties from Africa to be designated by states parties located in this region. As a basis for this designation, it is understood that, out of these 9 states parties, 3 members shall, as a rule, be the states parties with the most significant national chemical industry in the region as determined by internationally reported and published data. In addition, the regional group shall agree also to take into account other regional factors in designating these 3 members. b. 9 states parties from Asia to be designated by states parties located in this region. As a basis for this designation, it is understood that, out of these 9 states parties, 4 members shall, as a rule, be the states parties with the most significant national chemical industry in the region as determined by internationally reported and published data. In addition, the regional group shall agree also to take into account other regional factors in designating these 4 members. C. 5 states parties from Eastern Europe to be designated by states parties located in this region. As a basis for this designation, it is understood that, out of these 5 states parties, 1 member shall, as a rule, be the state party with the most significant national chemical industry in the region as determined by internationally reported and published data. In addition, the regional group shall agree also to take into account other regional factors in designating this 1 member. D. 7 states parties from Latin America and the Caribbean to be designated by states parties located in this region. As a basis for this designation, it is understood that, out of these 7 states parties, 3 members shall, as a rule, be the states parties with the most significant national chemical industry in the region as determined by internationally reported and published data. In addition, the regional group shall agree also to take into account other regional factors in designating these 3 members. E. 10 states parties from among Western European and other states to be designated by states parties located in this region. As a basis for this designation, it is understood that, out of these 10 states parties, 5 members shall, as a rule, be the states parties with the most significant national chemical industry in the region as determined by internationally reported and published data. In addition, the regional group shall agree also to take into account other regional factors in designating these 5 members. F. 1 further state party to be designated consecutively by states parties located in the regions of Asia and Latin America and the Caribbean. As a basis for this designation, it is understood that this state party shall be a rotating member from these regions. 24. For the first election of the Executive Council, 20 members shall be elected for a term of 1 year, due regard being paid to the established numerical proportions as described in paragraph 23. 25. After the full implementation of Articles 4 and V, the Conference may, upon the request of majority of the members of the Executive Council, review the composition of the Executive Council taking into account developments related to the principles specified in paragraph 23 that are governing its composition. 26. The Executive Council shall elaborate its rules of procedure and submit them to the Conference for approval. 27. The Executive Council shall elect its chairman from among its members. 28. The Executive Council shall meet for regular sessions. Between regular sessions it shall meet as often as may be required for the fulfillment of its powers and functions. 29. Each member of the Executive Council shall have 1 vote. Unless otherwise specified in this convention, the Executive Council shall take decisions on matters of substance by a 2/3 majority of all its members. The Executive Council shall take decisions on questions of procedure by a simple majority of all its members. When the issue arises as to whether the question is one of substance or not, that question shall be treated as a matter of substance unless otherwise decided by the Executive Council by the majority required for decisions on matters of substance. Powers and Functions 30. The Executive Council shall be the executive organ of the organization. It shall be responsible to the Conference. The Executive Council shall carry out the powers and functions entrusted to it under this convention, as well as those functions delegated to it by the Conference. In so doing, it shall act in conformity with the recommendations, decisions and guidelines of the Conference and assure proper and continuous implementation. 31. The Executive Council shall promote the effective implementation of, and compliance with, this convention. It shall supervise the activities of the Technical Secretariat, cooperate with the national authority of each state party and facilitate consultations and cooperation among states parties at their request. 32. The Executive Council shall a. Consider and submit to the conference the draft program and budget of the organization. b. Consider and submit to the conference the draft report of the organization on the implementation of this convention, the report on the performance of its own activities and such special reports as it deems necessary or which the conference may request. c. Make arrangements for the sessions of the conference including the preparation of the draft agenda. 33. The Executive Council may request the convening of a special session of the conference. 34. The Executive Council shall a. Conclude agreements or arrangements with states and international organizations on behalf of the organization, subject to prior approval by the conference. b. Conclude agreements with states parties on behalf of the organization in connection with Article X and supervise the voluntary fund referred to in Article X. c. Approve agreements or arrangements relating to the implementation of verification activities, negotiated by the Technical Secretariat with states parties. 35. The Executive Council shall consider any issue or matter within its competence affecting this convention and its implementation, including concerns regarding compliance, and cases of non-compliance, and, as appropriate, inform states parties and bring the issue or matter to the attention of the conference. 36. In its consideration of doubts or concerns regarding compliance and cases of non-compliance, including, inter alia, abuse of the rights provided for under this convention, the Executive Council shall consult with the states parties involved and, as appropriate, request the state party to take measures to redress the situation within a specified time. To the extent that the Executive Council considers further action to be necessary, it shall take, inter alia, one or more of the following measures. a. Inform all states parties of the issue or matter. b. Bring the issue or matter to the attention of the conference. c. Make recommendations to the conference regarding measures to redress the situation and to ensure compliance. The Executive Council shall, in cases of particular gravity and urgency, bring the issue or matter, including relevant information and conclusions, directly to the attention of the United Nations General Assembly and the United Nations Security Council. It shall at the same time inform all states parties of this step. d. The Technical Secretariat. 37. The Technical Secretariat shall assist the Conference and the Executive Council in the performance of their functions. The Technical Secretariat shall carry out the verification measures provided for in this convention. It shall carry out the other functions entrusted to it under this convention as well as those functions delegated to it by the Conference and the Executive Council. 38. The Technical Secretariat shall a. Prepare and submit to the Executive Council the draft program and budget of the organization. b. Prepare and submit to the Executive Council the draft report of the organization on the implementation of this convention and such other reports as the Conference or the Executive Council may request. c. Provide administrative and technical support to the Conference, the Executive Council and subsidiary organs. d. Address and receive communications on behalf of the organization to and from states parties on matters pertaining to the implementation of this convention. e. Provide technical assistance and technical evaluation to states parties in the implementation of the provisions of this convention, including evaluation of scheduled and unscheduled chemicals. 39. The Technical Secretariat shall a. Negotiate agreements or arrangements relating to the implementation of verification activities with states parties, subject to approval by the Executive Council. b. Not later than 180 days after entry into force of this convention, coordinate the establishment and maintenance of permanent stockpiles of emergency and humanitarian assistance by states parties in accordance with Article X, paragraphs 7, b, and c. The Technical Secretariat may inspect the items maintained for serviceability. Lists of items to be stockpiled shall be considered and approved by the Conference pursuant to paragraph 21(I) above. C. Administer the voluntary fund referred to in Article X. Compile declarations made by the states parties and register, when requested, bilateral agreements concluded between states parties or between a state party and the organization for the purposes of Article X. 40. The Technical Secretariat shall inform the Executive Council of any problem that has arisen with regard to the discharge of its functions, including doubts, ambiguities or uncertainties about compliance with this convention that have come to its notice in the performance of its verification activities and that it has been unable to resolve or clarify through its consultations with the state party concerned. 41. The Technical Secretariat shall comprise a Director General, who shall be its head and chief administrative officer, inspectors and such scientific, technical and other personnel as may be required. 42. The Inspectorate shall be a unit of the Technical Secretariat and shall act under the supervision of the Director General. 43. The Director General shall be appointed by the Conference upon the recommendation of the Executive Council for a term of 4 years, renewable for 1 further term, but not thereafter. 44. The Director General shall be responsible to the Conference and the Executive Council for the appointment of the staff and the organization and functioning of the Technical Secretariat. The paramount consideration in the employment of the staff and in the determination of the conditions of service shall be the necessity of securing the highest standards of efficiency, competence and integrity. Only citizens of states parties shall serve as the Director General, as inspectors or as other members of the professional and clerical staff. Due regard shall be paid to the importance of recruiting the staff on as wide a geographical basis as possible. Recruitment shall be guided by the principle that the staff shall be kept to a minimum necessary for the proper discharge of the responsibilities of the Technical Secretariat. 45. The Director General shall be responsible for the organization and functioning of the Scientific Advisory Board referred to in paragraph 21(h). The Director General shall, in consultation with states parties, appoint members of the Scientific Advisory Board, who shall serve in their individual capacity. The members of the board shall be appointed on the basis of their expertise in the particular scientific fields relevant to the implementation of this convention. The Director General may also, as appropriate, in consultation with members of the board, establish temporary working groups of scientific experts to provide recommendations on specific issues. In regard to the above, states parties may submit lists of experts to the Director General. 46. In the performance of their duties, the Director General, the inspectors and the other members of the staff shall not seek or receive instructions from any government or from any other source external to the organization. They shall refrain from any action that might reflect on their positions as international officers responsible only to the Conference and the Executive Council. 47. Each state party shall respect the exclusively international character of the responsibilities of the Director General, the inspectors and the other members of the staff and not seek to influence them in the discharge of their responsibilities. E. Privileges and immunities. 48. The organization shall enjoy on the territory and in any other place under the jurisdiction or control of a state party such legal capacity and such privileges and immunities as are necessary for the exercise of its functions. 49. Delegates of states parties, together with their alternates and advisers, representatives appointed to the Executive Council together with their alternates and advisers, the Director General and the staff of the organization shall enjoy such privileges and immunities as are necessary in the independent exercise of their functions in connection with the organization. 50. The legal capacity, privileges, and immunities referred to in this article shall be defined in agreements between the organization and the states parties, as well as in an agreement between the organization and the state in which the headquarters of the organization is seated. These agreements shall be considered and approved by the conference pursuant to paragraph 21, I. 51. Notwithstanding paragraphs 48 and 49, the privileges and immunities enjoyed by the Director General and the staff of the Technical Secretariat during the conduct of verification activities shall be those set forth in Part 2, Section B, of the Verification Annex. Article 11. Economic and Technological Development 1. The provisions of this convention shall be implemented in a manner which avoids hampering the economic or technological development of states parties, and international cooperation in the field of chemical activities for purposes not prohibited under this convention, including the international exchange of scientific and technical information and chemicals and equipment for the production, processing or use of chemicals for purposes not prohibited under this convention. 2. Subject to the provisions of this convention and without prejudice to the principles and applicable rules of international law, the states parties shall a. Have the right, individually or collectively, to conduct research with, to develop, produce, acquire, retain, transfer, and use chemicals. b. Undertake to facilitate, and have the right to participate in, the fullest possible exchange of chemicals, equipment and scientific and technical information relating to the development and application of chemistry for purposes not prohibited under this convention. c. Not maintain among themselves any restrictions, including those in any international agreements, incompatible with the obligations undertaken under this convention, which would restrict or impede trade in the development and promotion of scientific and technological knowledge in the field of chemistry for industrial, agricultural, research, medical, pharmaceutical or other peaceful purposes. d. Not use this convention as grounds for applying any measures other than those provided for, or permitted, under this convention, nor use any other international agreement for pursuing an objective inconsistent with this convention. e. Undertake to review their existing national regulations in the field of trade in chemicals in order to render them consistent with the object and purpose of this convention. Article 12. Measures to redress a situation and to ensure compliance, including sanctions. 1. The conference shall take the necessary measures, as set forth in paragraphs 2, 3 and 4, to ensure compliance with this convention and to redress and remedy any situation which contravenes the provisions of this convention. In considering action pursuant to this paragraph, the conference shall take into account all information and recommendations on the issues submitted by the Executive Council. 2. In cases where a state party has been requested by the Executive Council to take measures to redress a situation raising problems with regard to its compliance, and where the state party fails to fulfill the request within the specified time, the conference may, inter alia, upon the recommendation of the Executive Council, restrict or suspend the state party's rights and privileges under this convention until it undertakes the necessary action to conform with its obligations under this convention. 3. In cases where serious damage to the object and purpose of this convention may result from activities prohibited under this convention, in particular by Article I, the conference may recommend collective measures to states parties in conformity with international law. 4. The conference shall, in cases of particular gravity, bring the issue, including relevant information and conclusions, to the attention of the United Nations General Assembly and the United Nations Security Council. Article 13. Relation to other international agreements. Nothing in this convention shall be interpreted as in any way limiting or detracting from the obligations assumed by any state under the Protocol for the Prohibition of the Use in War of asphyxiating, poisonous or other gases, and of bacteriological methods of warfare, signed at Geneva on the 17th of June 1925, and under the Convention on the Prohibition of the Development, Production and Stockpiling of Bacteriological, Biological, and Toxin Weapons and on their Destruction, signed at London, Moscow and Washington on the 10th of April 1972. Article 14. Settlement of Disputes 1. Disputes that may arise concerning the application or the interpretation of this convention shall be settled in accordance with the relevant provisions of this convention and in conformity with the provisions of the Charter of the United Nations. 2. When a dispute arises between two or more states parties, or between one or more states parties and the organization, relating to the interpretation or application of this convention, the parties concerned shall consult together with a view to the expeditious settlement of the dispute by negotiation or by other peaceful means of the parties' choice, including recourse to appropriate organs of this convention, and, by mutual consent, referral to the International Court of Justice in conformity with the statute of the court. The states parties involved shall keep the Executive Council informed of actions being taken. 3. The Executive Council may contribute to the settlement of a dispute by whatever means it deems appropriate, including offering its good offices, calling upon the states parties to a dispute to start the settlement process of their choice and recommending a time limit for any agreed procedure. 4. The Conference shall consider questions related to disputes raised by states parties or brought to its attention by the Executive Council. The Conference shall, as it finds necessary, establish or entrust organs with tasks related to the settlement of these disputes in conformity with Article 8, Paragraph 21, f. 5. The Conference and the Executive Council are separately empowered, subject to authorization from the General Assembly of the United Nations, to request the International Court of Justice to give an advisory opinion on any legal question arising within the scope of the activities of the organization. An agreement between the organization and the United Nations shall be concluded for this purpose in accordance with Article 8, Paragraph 34, a. 6. This article is without prejudice to Article 9 or to the provisions on measures to redress a situation and to ensure compliance, including sanctions. Article 15. Amendments 1. Any state party may propose amendments to this convention. Any state party may also propose changes, as specified in paragraph 4, to the annexes of this convention. Proposals for amendments shall be subject to the procedures in paragraphs 2 and 3. Proposals for changes, as specified in paragraph 4, shall be subject to the procedures in paragraph 5. 2. The text of a proposed amendment shall be submitted to the Director General for circulation to all states parties and to the depository. The proposed amendment shall be considered only by an amendment conference. Such an amendment conference shall be convened if 1/3 or more of the states parties notify the Director General not later than 30 days after its circulation that they support further consideration of the proposal. The amendment conference shall be held immediately following a regular session of the conference unless the requesting states parties ask for an earlier meeting. In no case shall an amendment conference be held less than 60 days after the circulation of the proposed amendment. 3. Amendments shall enter into force for all states parties 30 days after deposit of the instruments of ratification or acceptance by all the states parties referred to under subparagraph B, below. A. When adopted by the amendment conference by a positive vote of a majority of all states parties with no state party casting a negative vote and b. Ratified or accepted by all those states parties casting a positive vote at the amendment conference. 4. In order to ensure the viability and the effectiveness of this convention, provisions in the annexes shall be subject to changes in accordance with paragraph 5. If proposed changes are related only to matters of an administrative or technical nature. All changes to the Annex on Chemicals shall be made in accordance with paragraph 5. Sections A and C of the Confidentiality Annex, Part 10 of the Verification Annex, and those definitions in Part 1 of the Verification Annex which relate exclusively to challenge inspections, shall not be subject to changes in accordance with paragraph 5. 5. Proposed changes referred to in paragraph 4 shall be made in accordance with the following procedures. A. The text of the proposed changes shall be transmitted together with the necessary information to the Director General. Additional information for the evaluation of the proposal may be provided by any state party and the Director General. The Director General shall promptly communicate any such proposals and information to all states parties, the Executive Council and the depository. B. Not later than 60 days after its receipt, the Director General shall evaluate the proposal to determine all its possible consequences for the provisions of this convention and its implementation and shall communicate any such information to all states parties and the Executive Council. C. The Executive Council shall examine the proposal in the light of all information available to it, including whether the proposal fulfills the requirements of paragraph 4. Not later than 90 days after its receipt, the Executive Council shall notify its recommendation, with appropriate explanations, to all states parties for consideration. States parties shall acknowledge receipt within 10 days. D. If the Executive Council recommends to all states parties that the proposal be adopted, it shall be considered approved if no state party objects to it within 90 days after receipt of the recommendation. If the Executive Council recommends that the proposal be rejected, it shall be considered rejected if no state party objects to the rejection within 90 days after receipt of the recommendation. E. If a recommendation of the Executive Council does not meet with the acceptance required under subparagraph D, a decision on the proposal, including whether it fulfills the requirements of paragraph 4, shall be taken as a matter of substance by the conference at its next session. F. The Director General shall notify all states parties and the depository of any decision under this paragraph. G. Changes approved under this procedure shall enter into force for all states parties 180 days after the date of notification by the Director General of their approval unless another time period is recommended by the Executive Council or decided by the Conference. Article 16. Duration and withdrawal 1. This convention shall be of unlimited duration. 2. Each state party shall, in exercising its national sovereignty, have the right to withdraw from this convention if it decides that extraordinary events, related to the subject matter of this convention, have jeopardized the supreme interests of its country. It shall give notice of such withdrawal 90 days in advance to all other states parties, the Executive Council, the Depository and the United Nations Security Council. Such notice shall include a statement of the extraordinary events it regards as having jeopardized its supreme interests. 3. The withdrawal of a state party from this convention shall not in any way affect the duty of states to continue fulfilling the obligations assumed under any relevant rules of international law, particularly the Geneva Protocol of 1925. Article 17. Status of the annexes. The annexes form an integral part of this convention. Any reference to this convention includes the annexes. Article 18. Signature. This convention shall be open for signature for all states before its entry into force. Article 19. Ratification. This convention shall be subject to ratification by states signatories according to their respective constitutional processes. Article 20. Accession. Any state which does not sign this convention before its entry into force may accede to it at any time thereafter. Article 21. Entry into force 1. This convention shall enter into force 180 days after the date of the deposit of the 65th Instrument of Ratification, but in no case earlier than 2 years after its opening for signature. 2. For states whose instruments of ratification or accession are deposited subsequent to the entry into force of this convention, it shall enter into force on the 30th day following the date of deposit of their instrument of ratification or accession. Article 22. Reservations. The articles of this convention shall not be subject to reservations. The annexes of this convention shall not be subject to reservations incompatible with its object and purpose. Article 23. Depository. The Secretary-General of the United Nations is hereby designated as the depository of this convention and shall, inter alia, a. promptly inform all signatory and acceding states of the date of each signature, the date of deposit of each instrument of ratification or accession and the date of the entry into force of this convention, and of the receipt of other notices. b. Transmit duly certified copies of this convention to the governments of all signatory and acceding states and c. Register this convention pursuant to Article 102 of the Charter of the United Nations. Article 24. Authentic texts. This convention, of which the Arabic, Chinese, English, French, Russian and Spanish texts are equally authentic, shall be deposited with the Secretary-General of the United Nations. In witness whereof the undersigned, being duly authorized to that effect, have signed this convention. Done at Paris on the 13th day of January, 1993.